questions about the state-mandated consent to act form. There's a lot of rumors out there about when it should be used and how it should be signed. The goal of this legal minute is to cut through the confusion and provide clear information. First, let's clear the air and understand when the consent to act form must be used. It must be used when an agent will be representing more than one party. In Nevada, we don't call it dual agency because dual agency is a common law term, and Nevada repealed common law principles as it applies to the statutorily defined duties of a licensee. Also, another point of confusion is real estate licensees think the consent to act is used when the agent will be representing the buyer and the seller in the same real estate transaction. But again, the consent to act is used when an agent will be representing more than one party. And so it must also be used if the agent is representing more than one buyer in the same real estate transaction. And that makes sense, right? Because whether an agent is representing parties on both sides of the V or on the same side of the V, there are competing and conflicting interests, hence necessitating the disclosures and permissions provided for within the consent to act form. Lastly, members frequently ask, do parties' signatures have to be on the same consent to act form? Nope. If an agent will be representing more than one party, the agent can use one form for each client, or both clients could sign the same form. The important thing is to have it signed. Remember, this form is giving authority to the licensee to act for more than one party to the transaction. The agent should keep these signed forms in their files to demonstrate compliance, and should the need arise, would produce both signed forms to the Real Estate Commission. Check out our corresponding article on the Consent to Act form, available on our website's Legal Center. Thank you for watching today's Legal Minute.